Hello, my name is Crystal Dahl, and I'm the Online Communications Specialist here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, Beware of the Inadvertent Franchise. Before we get started, I would like to quickly go over a few housekeeping items. Meritas now offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. Just send me a chat message and I'll send that phone number on to you. If you experience any technical difficulties, please press *0 at any time to connect with a support technician, or again, you can send me a chat message. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. Questions will be answered at the end of the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as each of the presenters' contact details. You are welcome to reach out to them individually if you'd like, if you still have questions. Our presenters today come from the Meritas affiliate Greensfelder, Hemker & Gale in St. Louis, Missouri. Leonard Vines concentrates his practice on franchise and distribution. Kimberly Myers brings broad experience in business and franchise legal matters, including several years as a general counsel for retail pharmacy franchisor Medicine Shop International. Welcome, Kim and Lenny. With that, Lenny, are you ready to get started?
I'm ready to begin. Good afternoon, everybody. Thanks for joining us. We've got a really nice crowd of people, so we're very pleased that the topic is of such great interest. This afternoon, what we're going to try to do is to give a basic primer, just an introduction to the basic laws of what constitutes a franchise, because so often business people and attorneys fail to recognize a relationship that meets the definition of a franchise. So we want to give you the things to look for and basically kind of go through what is a franchise, what laws are applicable if it is a franchise, are there any alternatives that you can do in order to avoid being classified as a franchise, what kinds of risks do you face if you are a franchise and don't realize it? And then we'll conclude with some practice pointers that hopefully can help you in your day-to-day practices, and we will open it up to a few questions, maybe in about 5 or 10 minutes at the end of the program. In kind of a rhetorical question, how many of you, and of course you don't need to answer, have been contacted by a client or somebody in your company who says, well, we don't really want a franchise, all we want to do is license. Or somebody contacts you and says, well, we're not really ready to franchise yet, we're really just licensing. That obviously is a big signal, because once you hear the word license, you should really, the first thing that should come to mind is whether or not it might fall into the franchise trap. Really, any company that engages in the business of selling goods or services through distribution or sales programs should evaluate their systems and procedures to determine whether they're in compliance with the franchise laws or regulation, regardless of what the relationship is called. Now, Kim, I'll turn it over to you to talk a little bit about the traps that people fall into.
Okay, thank you, Lenny. Here on this first page, this first case that we have up, it really shows that both lawyers and clients really do often fail to understand how broad the franchise laws actually are. The franchise laws, along with related laws that govern these relationships, may cover business structures that are very different from what is typically thought of as a franchise. We all understand the McDonald's, the Burger Kings, and those sorts of business models, but certainly many business models fall under the definition of a franchise, and many are not aware of that. And that did happen in this first case that we have on the first slide. In this case, the plaintiff was a licensed dealer of Mitsubishi Forklifts under a dealer agreement between the parties. In this case, Mitsubishi terminated the dealer agreement in compliance with the termination provisions in that agreement. But nevertheless, the plaintiff distributor sued, claiming that Mitsubishi terminated the dealer agreement in violation of the Illinois Franchise Disclosure Act. And this act permits termination of a franchise only for good cause and requires the so-called franchisor to repurchase the franchisee's inventory. In this case, the jury awarded over $1.5 million to the terminated distributor. The Seventh Circuit Court of Appeals, when they affirmed, stated that legal terms often have specialized meanings that can surprise even a sophisticated party. And the terms franchise and related words like franchisee are one of those words. So in a few minutes, Lenny is going to discuss in detail the definitions of a franchise. But for now, what's important to know is that it doesn't matter if the parties to a business arrangement do not want it to be a franchise. It doesn't matter what name they give their business structure. And it doesn't matter if they are even aware or unaware that their chosen business structure meets the definition of a franchise. The Federal Trade Commission, the federal agency that regulates franchises, and the various states with franchise or dealer laws, they take the approach that if the definition is met, it's a franchise. This approach can present issues for many because the franchise laws are complex and definitions do vary from state to state. So sometimes a business arrangement is a franchise in one state but not another state. So many of us will recognize the traditional franchise concept of, say, a popular local restaurant that wants to expand through franchising. However, there are many structures that meet this definition that may not be obvious without a thorough understanding of these laws. So what are the consequences then of not understanding when a franchise is a franchise? Well, the consequences can be severe. We have here a couple of examples of what can happen. One is the Mitsubishi case we've already discussed, in which the franchisee or the dealer was awarded over $1.5 million in damages for a termination that was in violation of the Illinois Franchise Act. The second case was involving Adolph Coors, and they were hit with double damages over $10.2 million plus attorney fees for failure to give written notice and an opportunity to cure. So under the FTC franchise rule, there is no private right of action for a violation of that rule, and the FTC has limited resources and has not been actively pursuing violations other than in the most egregious cases. However, we would never recommend that you ignore the FTC rule by any means. Among the states, though, remedies do vary, and they may include things such as rescission and restitution, or damages, sometimes even triple damages, as well as costs and attorney fees. There can also be personal or even criminal liability for officers and directors of franchisors who don't comply with these laws under some of the state statutes.
And, as these cases point out, we're dealing with, big name companies that probably have extensive legal departments and very sophisticated people who are giving them advice, and even there, such as Mitsubishi and Adolph Coors Brewing, you can see that they can fall into this trap and not recognize that the relationship's a franchise and not carefully look at the different federal and state laws that might be applicable.
So, and then not only is the client subject to sometimes severe consequences, but attorneys may face potential liability as well. And on this slide, we've illustrated a couple of examples. In the first case listed, the Beverly Hills case, I will point out that actually involved a state business opportunity law, which Lenny will discuss later. The business opportunity laws are somewhat akin to franchise laws, and that's beyond the scope of the presentation other than we want to point out how to recognize them. In the second case, in Pyramid Controls, the attorney missed the statute of limitations for a terminated dealer. the court rejected the attorney's argument that the law is so obscure that few know how it works or even that it exists. So it's certainly in everyone's best interest that we understand how to recognize a franchise and what we need to do about it.
So, the real question comes in, what is a franchise? And there is really no universal definition of a franchise. There's a definition that the Federal Trade Commission uses in classifying franchises, and there are also varying definitions at the state level that we'll talk about. But generally speaking, in the broad general sense, there's really two key types of franchise. One is a package or business format franchise, and this is a situation where a franchisee adopts a business format that is established by the franchisor and is identified by the franchisor's trademark. The other is a product franchise, where a franchisee distributes goods that are produced by the franchisor and which bear the franchisor's trademark or manufactured by the franchisee according to the franchisor's specifications. So obviously, on this slide, this just shows a few logos from some of the more well-known franchises. As we've said, franchising is certainly not just limited to fast food restaurants, even though that seems to be the one that comes to mind. Franchises involve all types of goods and services in the automotive, business services, commercial, residential, education, lodging, personal service type businesses, all types of retail establishments, restaurants, real estate agencies and brokerages, senior care and medical services, and even in some situations, for example, there can be something that you might think would never even be considered a franchise, but there can be a dental practice, for example, or a medical practice that would meet the definitional elements of a franchise that nobody would really ever even think of, and that brings in not only all the different professional rules and regulations that relate to the business, but then this whole additional layer of medical laws and the laws for any professions such as legal, architectural, or dental. So under the federal law, there are basically three key elements that constitute a franchise. And if these three elements are met, the relationship will be considered a franchise. Now, we are talking about this in generalized terms, of course, so there are little nuances and exceptions and interpretations, but generally speaking, when you see all three of these elements, that's going to clue you in to recognizing that you better at least look to see if this might be a franchise. And those three elements are, number one, a fee or a required payment. This is very broadly defined, at least for federal purposes, an initial fee, a royalty fee, a payment for a training fee, a payment for products that are purchased from the franchisee. Those will all qualify. So if there is a fee that's being paid from the franchisee to the franchisor, and if it's in excess of a certain amount of money, generally a little bit more than $500 during the first 6 months of operation, then that element is satisfied. So typically, that element is very difficult to get around when you're establishing the relationship. One note is that if the payment is for wholesale purchases of inventory at a bona fide wholesale price, and if the purchases are not for unreasonably large amounts of inventory, then that will not be classified as a fee. So one way of at least getting around the franchise laws is a situation if a manufacturer is simply selling inventory at wholesale prices, but without charging any other types of hidden fees. The other is continuing control or assistance. The federal law gives a long list of the types of things that constitute continuing control or assistance. Generally, they're in the nature of training and marketing programs and site selection assistance or advice on how to run the business. And then the third element, and a critical element, is if the relationship is associated with the offer or sale of goods or services using the franchisor's trademark. Again, the use of the trademark, that's going to be broadly defined in the federal law. So once you see a trademark, that's one of the very, very key times that you have to really open your eyes. Now, keep in mind that the state definitions can differ from the federal definitions, and under both the state and the federal, there are certain exemptions and exclusions from the definition of a franchise. To go through, and again, when we deal with exemptions from the franchise laws, what we're saying is that the three elements of the franchise definition might be met. However, the government, the Federal Trade Commission, has decided that certain types of arrangements, even though they might technically meet those three definitional elements, should not be classified as a franchise. One of them is a fractional franchise, and that is a situation where someone who is already experienced in a particular business and has at least 2 years of experience in the business and expects that the goods or services that are going to be provided will constitute less than 20% of the total volume of their sales, then it's viewed as just being an ancillary adjunct to the business and not subject to the franchise disclosure rules under the Federal Trade Commission Act. Another one is a leased department. There are certain leased departments that might have the three elements, but those are exempt. Purely oral arrangements are exempt, but in order to qualify as a purely oral arrangement, it's virtually impossible to do so because almost any kind of writing would take it out of the exemption. Petroleum marketers and resellers are governed by their own body of law, so they are not subject to the requirements of the Federal Trade Commission. And then within the last 8 years or so, the Federal Trade Commission has recognized 3 other types of exemptions that are broadly classified as sophisticated investor exemptions. One is if the franchisee is going to make a large investment of over $1 million+ in certain types of investments with relation to the business. The next is if the franchisee has a high net worth, generally north of $5 million. And then there is also an exemption when the franchise is sold to an insider with the company, which is really basically someone who is already a director or officer in the business and has already knowledgeable in the business and has been working for the business. But under federal law, there's really no exemption for franchisors that are, large franchisors that they themselves have a high net worth or that have a certain number of franchises. However, some state laws do have that type of exemption. There are also exclusions, and these exclusions mean that if something falls within these categories, such as the employer-employee or general business partner relationship, a cooperative association, a a trademark license for a service to evaluate and certify goods, or a single trademark license. The Federal Trade Commission has decided that these don't constitute franchises, that they really don't fall within the definition, so they don't even consider them to be franchises. And although the Federal Trade Commission rule doesn't specifically name these types of exclusions as being exempt from qualifying for the franchise laws, the previous laws before the FTC rule was revised specifically included these, and the FTC now basically takes the position that it is so commonplace that everybody knows that these types of arrangements that are on the screen now are not intended to be covered by the requirements of the FTC rule. Now, as we've said, there's no universal definition of a franchise. I've gone through the 3 key elements of a franchise for purposes of federal law, but the states have their own definitions. And you have to be very careful. This is really where you can get into trouble if you don't look at the definitions of what a franchise is under a state law. Because just because something's not a franchise under federal law doesn't mean that it's not a franchise under state law, and vice versa. Generally, for all kinds of state laws, you're going to still have a trademark element and a fee element, and some type of control or assistance. And rather than using the term continuing control or assistance, some of the states use the term a marketing plan or system, and some states use the term community of interest in marketing goods or services that use the franchise fee. So it's a little bit different definitions, but what you run into is that you have to look at the cases under each of the state laws to really decide what is a marketing plan or what is a community of interest. So the definitions, even among the states that use the same terminology, may not necessarily be exactly the same, and some of the cases that interpret those definitions may not be the same. Just one little caveat, New York is one of the only states that does not require 3 elements for a franchise. In New York, you're going to be a franchise if either there's a marketing plan and a fee or a trademark license and a fee. So as a caveat to all of you, when you're in New York, the definition of a franchise will encompass a typical run-of-the-mill trademark license, because the definition under the New York law is so broad and so all-encompassing. So really take a lot of care. And in New York, the law can apply even if the franchisor is selling a franchise to somebody outside of the state of New York, if the franchisor is located in the state of New York. Kim?
Okay, thank you, Lenny. Okay, so Lenny just went through all these confusing definitions of what a franchise is and possible exemptions and exclusions. So you have a client that comes to you. They describe their business arrangement and their structure. They want you to help them. And because you took this seminar, you now understand that this business arrangement probably meets the definition of a franchise. So what does that mean? What are the ramifications? And what do you do with that? So one of the first questions you should ask is whether the state in which your client wants to sell or offer for sale a franchise, is it a state in which they have a franchise law on the books or not? There's 14 of them, and we'll get to which states those are in just a minute. But if not, if that state does not have a registration and disclosure law, the transaction is still, however, subject to the FTC franchise rule. The FTC rule requires disclosure but not registration. This means that the franchisor must produce a franchise disclosure document, which is also referred to as an FDD, that includes the information and meets the requirements of the FTC rule. So all franchisors have to have this document. There's a number of items in there, and all franchisors have to include the same pieces of information in the same order that's required by the rule. The FDD does not have to be registered at the federal level with any agency, but it must be given to a prospective franchisee at least 14 days prior to the franchisee signing a franchise agreement or paying any money. The FTC rule does not govern the ongoing relationship, only the disclosure prior to the sale. So then, if you determine that you happen to be in a state in which there is a franchise law, then the franchisor must meet the requirements of that state and register its franchise disclosure document with the relevant state agency. And also keep in mind, if you have a client that already is or wants to go into multiple states, you may have to register in all 14 of the registration states if that's where they want to do business. Some states merely require the FDD to be registered with the state, and the state will not conduct a review to determine if it meets the legal requirements. Once you file in that state, your client is good to go in terms of offering franchises for sale. However, other states will conduct a thorough review of the disclosure document and may require changes to the FDD prior to approving it and prior to permitting the franchisor to sell franchises in that state. So beyond the federal and state franchise laws, there are also special industry laws of which you should be aware. Lenny will later discuss the business opportunities law, but there's also, in some states, automobile dealership laws. There may be farm and industrial equipment dealer laws or motor fuel franchises, boat dealers, beer and liquor distributors. Those could all be separately regulated under state law. And these special industry laws usually govern termination and not renewal, and typically do not require a pre-sale disclosure or registration of any sort. So those registration states I mentioned are shown here on the map in green. And these are the states that separately govern both registration and disclosure obligations, and that's prior to the sale. The states are Washington and California on the West Coast. Then we have North Dakota, South Dakota, Minnesota, Wisconsin, Illinois, Indiana, and Michigan in the upper Midwest. And then we have New York, Connecticut, Delaware, Maryland, and Virginia along the East Coast. Okay, so you've gotten your client through the disclosure and registration obligations. They have their FDD, they're out, they're selling franchises. So they're in business and things are humming along. Then you have a franchisee who maybe isn't performing well or something's going on and your client wants to terminate the franchisee. What do you have to worry about then? Well, there are a number of states, and these states may not be the same as the 14 states we just discussed, that may have state relationship laws. The state relationship laws govern certain aspects of the relationship after it is formed. So some states that do not have pre-sale registration and disclosure laws may nevertheless have relationship laws. The FTC, on the other hand, only governs pre-sale disclosure, but does not address the ongoing relationship. The subject matter of these state relationship laws usually cover termination, repurchase requirements, and renewals. So as far as terminations, they frequently require a certain amount of notice, may only allow termination for good cause as defined in the law, or may require the franchisor to repurchase the franchisee's inventory upon termination. So you may recall the Mitsubishi case we discussed at the beginning of the presentation. The dealer in that case was found to be in violation of one of these state franchise relationship laws. As far as renewals, some states may grant the franchisee the right to renew its franchise agreement except for certain reasons, such as material defaults. And then other relationship laws may cover topics such as discrimination between franchisees or restricting free association among franchisees. There are others, but the point being is that if a franchise is involved, you also need to be aware to look for these state relationship laws.
And let me just to clarify, because we've used the term franchise disclosure document, or sometimes it's called the FDD. Years ago, it used to be called the Uniform Franchise Offering Circular, and in many respects, it was somewhat uniform, but not completely uniform. But basically, the franchise disclosure document, or the FDD document, I don't know how many of you are familiar with it. It's very much like a prospectus for a securities offering. The franchisor is required in all 50 states by virtue of the FTC rule to deliver a franchise disclosure document that contains all types of information about the background of the franchise, the laws that are applicable to the franchise, the costs and expenses that are going to be incurred if they're going to buy into the franchise, information about listing people who have bought franchises so that franchisees or prospective franchisees are able to call those people and ask them questions about it. You're also required to provide audited financial statements for 3 years, and there are also certain restrictions on the types of information that you can include. There are detailed requirements of how to write the franchise disclosure document, what goes in there and what shouldn't go in there. And in particular, one of the areas that you've got to be real careful about is if you make any statements about earnings, any claims about what the franchisees might earn or what other franchisees have earned in the past. Those are known as financial performance representations. There is at this time, no legal obligation to provide financial performance representation in the disclosure document, and if the franchisor doesn't want to disclose it, they can just indicate that they're not going to give any disclosure about any types of earnings or financial performance. But then again, that's kind of pretty important information to somebody who's buying a franchise. But, you do have to be very, very careful in preparing that disclosure document. It's got to be given out all over the country. Only certain states require that you let the state approve it and review the disclosure document before you can sell a franchise. And even if there is no franchise registration law in a particular state, bear in mind that there still may be other laws that relate to the relationship between the franchisor and the franchisee. So, for example, if you take the state of Missouri, there is no obligation in the state of Missouri to give a disclosure document by law, but the federal law says you have to, so the federal law applies. But the definition of a franchise in Missouri, for example, is much broader than the definition of a franchise for federal law purposes. So, for example, a furniture manufacturer that uses a trademark may be a franchise and may be subject to the law in Missouri that basically says you've got to give 90 days notice before you can terminate a franchise, even though there's no registration requirement or any review of the franchise offering in the state of Missouri. And there are a lot of other states like that. I'm just using our home state as the example. So you've got this myriad of laws that relate not only to registration, but to disclosure and to the relationship between the franchisees. So that's where it really gets tricky, because you've got to look at all these different laws, and there are certain consequences if you don't comply with one set of laws, and certain consequences if you don't comply with another set of laws. So it's just, beware, be sure that you look at those state statutes very, very carefully before making any decisions or before terminating or taking any action against somebody with whom you've got a relationship, regardless of what the agreement says. For example, let's assume you've got a franchise agreement that both parties have signed, and it says that the franchisor can terminate the franchisee on 30 days' notice for any reason. Well, there may be a state law that says you can only terminate for good cause, or that you cannot terminate until you give 60 days notice, or that you cannot terminate until you give an opportunity to cure. So you cannot just rely on what is in the written document. You've got to look at the particular state law to be sure that you follow that to the letter. Okay. And next, these next two slides really are going to basically give you just an example of various cases that we have found in looking through different states on the varying definitions of franchises and some of the cases that have interpreted certain relationships that most people might say, well, wait a minute, that's not really a franchise, that's just a license arrangement, or that's just a distribution arrangement, or that's just a sales representative arrangement, or any kind of other name. But, as you'll see from this list, these are just a few that we have found. And a lot of people, it goes by various names. We've kind of called our topic today the inadvertent franchise. Sometimes people call them the hidden franchise, the disguised franchise, or the unsuspecting franchise. But on this first slide, you can just take a look at that. I don't need to repeat them. But this gives you an example of the types of things that have been found to be franchises under various state laws, maybe not necessarily to register the franchise, to sell a franchise, but perhaps to regulate when or how a franchise can be terminated or not renewed, or whether any other specific statutes might apply to the relationship. Next, we're going to just touch briefly on another group of laws that are applicable in about 25 states that are highlighted in a color on the map that's in front of you. And the reason is that these are so-called business opportunity or seller-assisted marketing plan states, and these are ones that perhaps I'd probably say that if there might be a lot of people out there who don't recognize a certain relationship as being a franchise, and probably there are 10 times as many people who don't recognize that a particular relationship might be considered a business opportunity law state. Now, there's also a separate business opportunity law in the Federal Trade Commission that really is a very, very, very narrow definition. So I'm not going to talk about that right now. I'm just going to point out that in these states, the definitions of a business opportunity also differ widely. They have a lot of similar characteristics, but the definition's not always the same. But generally, if you are in a situation in one of these states and you're involved in a business relationship that involves the sale or lease of goods or services to start a business, and the payment of a fee, and usually certain types of representations or promises that are made to the potential buyer in order for that buyer to start a business, you could very well be classified as a business opportunity. Now, an interesting point here is that there is no requirement that there be a trademark associated with the business opportunity. So sometimes somebody thinks, well, I'm going to avoid associating my business with a trademark, and then I don't have to worry about being a franchise. Well, the problem is you then fall into this trap of being subject to the potential business opportunity laws of 25 states, and those laws, in many situations, are more onerous and more difficult to comply with than even the franchise laws. The definitions are varied. You've got to be very careful about, how they're defined and what they cover and what exceptions there are. A lot of the states will also require you to prepare a disclosure document and provide financial information. They may require that you post a bond in order to sell the franchise. They may require a review at a state agency. So the real point here is that a lot of times, as we say, if you try to fall outside the franchise laws and try to come up with a way to avoid it, you could end up getting yourself into even a bigger mess. And it may sometimes be better to just bite the bullet, treat the relationship as a franchise, do your disclosure document, register with the particular state, and then follow the laws that relate to the franchises. The business opportunity laws are really complex, really varied, and you're going to spend more time, although, as I've said, the Federal Trade Commission rule on franchising is not entirely uniform, but it is really quite consistent throughout the country. And there are little differences between each state, but those are readily identifiable and easy to see what they are because there's so many franchise filings available, and it oftentimes only requires that you include a particular state law addenda that pertains to the particular laws of that state, and you can use the basic franchise disclosure document in all 50 states of the country, whereas the business opportunity laws don't give you that freedom.
Okay, so you and your client have discussed its business objectives and requirements of being a franchise, and the client has decided it wants to avoid being a franchise. It doesn't want anything to do with producing a disclosure document, with registering, or treating itself as a franchise. So what do you do? And, as Lenny already mentioned with respect to the business opportunity laws, first, you should consider and take into account that attempts to avoid being a franchise can sometimes be more difficult and more onerous than complying with the franchise laws. And many times these attempts to avoid being a franchise can also necessitate changes to the underlying business model or business arrangement to such an extent it no longer meets the primary business objectives and may not make economic sense any longer. So in any event, so you want to find alternatives to franchising. Typically, those efforts focus on eliminating one of the three elements of the definition of a franchise. So, for example, if there is no association with a trademark, there may be control or assistance or a community of interest, and a payment of a fee, but if there's no common trademark involved, then you may fall out of the definition of a franchise. Or you could focus on one of the other two elements, like no payment of a fee of any kind. And as Lenny had mentioned, this would not apply to a fee for goods at a bona fide wholesale price. Or you could focus on the control or assistance or community of interest element. So Maybe there's a license of a trademark and a payment of a fee for that license, but nothing else involved. So then, the slide here as well as the next one, it does list some of those alternatives to franchising and what they might look like in terms of a business arrangement or structure. Things like granting a license to make or use a product, invention, or secret process, or granting a trademark license to use a particular, to be used in connection with the sale or use of a product or services. A direct distribution arrangement or management agreements. Those can frequently be structured to not meet the definition of a franchise. Other things such as consignment operations, sale of company-owned outlets. That's another thing to discuss with clients. Franchising is typically a way to expand by using other people's capital, other people's money, and so that the franchisor doesn't have to hire a bunch of people, invest in perhaps the real estate and the cost of expanding themselves. And they can do it through franchising so that other people put up the money. But in some instances, maybe they'd rather open company-owned outlets instead of franchise them. Also, certain agency or supply relationships. Again, you always have to look for which element is missing from the analysis. Also, independent manufacturers reps or sales reps who sell manufacturers' products. And then, as we've mentioned a number of times, sale of goods only at bona fide wholesale prices. All of those things can take you out of the definition of a franchise. But again, you always have to be careful that one of the elements of a franchise is missing, and make sure, because oftentimes these elements are very broad and can cover a lot of different arrangements that you might not initially think would be covered.
Okay. Now let's just kind of, in bringing it all together, give you some practical advice and some tips and pointers that hopefully you can get some good use out of in your day-to-day practice or in the business that you're involved in. On just when you're faced with these issues. One is, look at the definitions of a franchise, both at the federal and the state level, so that you can determine if you fall within it. You've got to look at the statutes. There are generally, in many states, not all, there are also state regulations that you should look at, and you should also look at the case interpretations. I might also add that the American Bar Association Franchise Forum has just a wealth of resources, and their papers are online for members of the ABA Forum from seminars going back many years, and there are extensive papers and articles in franchise law journals that really go into all of these topics in great detail. So if you're dealing with any franchise issues, I would really urge you to contact somebody who has access to the vast library and resources of the ABA's forum on franchising without putting in a plug for that. The next is that, we do, when you see the word trademark or trademark license, that is a red flag because that's one of the key elements of the franchise. One note, if the trademark license, if the only controls and assistance that are provided, and if you make narrow use of how much you control the business and limit it to the requirements under the Lanham Act to protect your trademark, then you can fall outside the scope of the franchise, even though you technically have the trademark element. So when I went through the very first three elements of the franchise, and we talked about the association with the trademark, and if you recall, we talked about the fee and the continuing assistance. If the continuing assistance is strictly limited to protecting the trademark, then you will not be considered a franchise. You want to look at the exemptions and the exclusions that we touched on briefly, keeping in mind that the definitions for the exemptions and exclusions are not at all uniform. Some states have similar ones, and in some cases you may be able to look at a statute that is very, very closely worded or exactly worded like another state to at least get guidance from that state. And also, if you do get into an area, California, for example, was the very first state that enacted a franchise law back in the late 70s. And the state of California has a publication on what is a franchise that goes into a very in-depth, excellent discussion of the different elements of a franchise if you start getting into a technical area, keeping in mind that that relates to the California law, but a lot of that California law is applicable in other states. We also pointed out that there are special industry laws, equipment manufacturers, agricultural dealers, automobile manufacturers. Look for the special industry laws of the state to see if they have any specific requirements. They may have certain requirements on, terminating a dealer or what kind of notice you've got to give in order to terminate a dealer. So even though those might not be franchises per se, they still are subject to this group of laws that are very similar to franchise laws and govern the relationship. Next, do not rely on disclaimers in the franchise agreement. Generally speaking, putting a statement in the franchise agreement, although it might not hurt anything, but if it says the parties hereby acknowledge that we are not intending to create a franchise, or language of that sort is not going to generally be upheld, and the courts won't let the parties disclaim their right to enforce a statute. Don't forget the business opportunity laws. They don't apply in all states, but they apply in about 25 states. When talking to your clients, you might want to explain to them that, rather than have us spend a lot of time looking for loopholes that might apply in one state but might not apply in another state, or might apply at the federal level and don't apply at the state level, it might be more economically feasible to go ahead and treat it as a franchise, have it comply with the disclosure and registration requirements to the extent necessary, and not be so afraid of what some people call the F word. It is burdensome. There are a lot of problems with doing it under appropriate circumstances. If there are ways to restructure the relationship in order to avoid being classified as a franchise comfortably, by all means, you can look to that. But if you're expanding nationwide, you do have to be very, very careful because you're really dealing with the laws of 50 states. Next, as I've said, don't rely on what the agreement says. Just because the agreement says that you can terminate the relationship in 30 days doesn't mean that there's not a state law that overrides that. And then one other point along those lines, the Federal Trade Commission law on franchising does not preempt state laws. So if there is any type of state law that gives a franchisee broader protection than what they would have under the FTC franchise law, the state law will take precedence over it. Next, educate your clients and the people that you work with, or the business people in your organization, so that they know what types of things to look for and so that if they do see some of these signals of something that might spark them to think that, wait a minute, this might be a franchise, let them, give them some basic training, some education, so that they'll know what to look for and alert you if you see a problem. Okay?
Okay. Thank you, Lenny.
Thanks.
And we do have some questions already. Let me see. The inadvertent franchise slides, someone has asked for some examples of why they were determined to be franchises. So here, let me back up to the list. So, Lenny, did you take that one?
Okay, sure. Okay. Well, the reason, when we say an inadvertent franchise, it's really going to be quite easy as to why they were considered a franchise, because the state that looked at the relationship made a determination that the elements of a franchise were, in fact, satisfied. So if you take an appliance dealer, okay, I'll just take the very first one and use that as an example, and then maybe that'll kind of follow through. An appliance dealer might be operating a business where the manufacturer, say Maytag, for example, gives them the right to sell their products bearing their trademark. And in addition to perhaps requiring them to buy inventory from Maytag, they might also require them to attend training programs, and they might charge them a fee to attend training programs. So then you're getting into a situation where they're paying a fee in addition to buying products at wholesale. Now, this can get into a very complicated area, and of course, when you look at all these and all the little nuances, somebody might say, well, the appliance dealer that's selling Maytag, really, Maytag isn't controlling their entire business operations. Well, that's going to be kind of a question of fact. And it may be that a particular state law says that our definition of a franchise involves a community of interest. And in that particular state, they might say, well, both parties have this same mutual interest of earning a profit and expanding the brand. So that the court could say there's a community of interest, there's a fee, and there's the use of a trademark. Now, in some situations, in some states, they might say, well, if that Maytag dealer is really selling all kinds of other products and is not really just a captive Maytag dealer, then they might fall within the definition of a fractional franchise, and it may be that Maytag only constitutes a small portion of their sales, less than 20%, and that if they've been in business for 2 years. But if it's a captive Maytag dealer and it's a Maytag store, for example, something that you might not really think of, you just think it's a manufacturer and we're selling goods. And I don't know that necessarily this case involved Maytag, so I'm just using that as an example.
And another thing to point out is all of these arrangements on here aren't necessarily franchises. Some may be and some may not be. You really have to look at the underlying facts and, as Lenny mentioned, are there any hidden fees? One appliance dealer and their relationship may be determined to be a franchise because there were hidden fees involved, and the one down the street may not be because their arrangement was different and there weren't the same requirements or the same fees. So these are just examples of possibilities, but you always have to look at the underlying facts because it's a very fact-specific analysis. Okay, and then we do have another question, is whether we can provide any case law or background or other details where a sales rep was found to be a franchise. Sales representative.
Let me give you an example. When we talk about a sales representative, this too, and we're actually at the end, but we'll take this last question. And let me just mention, as an aside, many states have what they call sales representative laws, that if salesmen operate on a commission basis, for example, there's certain laws that pertain to termination of the sales rep, and that's getting into a whole different area, but those sometimes you do read about sales representative laws along with franchise laws. One exception, and what you might be thinking of in this question, is that if someone is a commission representative, that might not constitute a franchise. And there is an FTC footnote in one of the Federal Trade Commission guidelines that discusses commission representatives, and in situations where the payments are made directly to the franchisor, the company, rather than to the salesman. And if the money goes to the franchisor and the franchisor works on a commission and just gets a certain percentage, generally speaking, they will not be considered a franchisee unless they have to pay a fee in order to become a sales representative, or if they have to pay a fee to the franchisor in order to have that right to become a commissioned sales representative. And, as with all of this, please keep in mind, just as a general rule, we're doing a broad brush stroke of all of these laws. When you get into all the different elements of the franchise on what constitutes a fee and, who is certain types of payments to third parties are not considered a fee. It usually only applies if there's a payment made to the franchisee and not a third party, but there are other exceptions. If the third party pays a rebate or a commission to the franchisor, then it will fall within the definition of a fee. But it looks like we are already a little bit over our time limit, so we would welcome if you've got our email addresses, if you have specific questions, or if you want to call either one of us, we'd be more than happy to entertain any questions and help you.
That was great. Thank you so much, Kim and Lenny. It was truly a pleasure to have the chance to listen to you today, and it was definitely a very informative presentation. Before we sign off, I just wanted to remind each of you that in the next few days I will distribute a copy of this presentation, a recording of the webinar, as well as both Kim and Lenny's contact details. As he mentioned, you are more than welcome to reach out to them directly if you have anything that you'd like to talk to them about, any questions, comments, concerns. With that, thank you again for taking the time to join us, and I hope everybody has a great day. Goodbye.
Thank you. Great. Thank you, Crystal. Thanks, everyone.